Great. So yes, thank you very much for that introduction. I feel like a little bit that I have grown up with the regulation, in particular the European regulations, as they've gone through their different guises and the various discussions that have happened in the past over many years. We'll talk a little bit about. We will talk, I think, principally and primarily about the GDPR and the European regulations and the changes that are happening there. But I think it's first important to take just a quick step back and look at data protection, some of the principles around data protection, and also the global nature of it. That it is not, while there is a lot of talk and there's definitely a lot of energy being spent in Europe on this topic, it is not exclusive to Europe. And so in that respect, we will move forward and talk through sort of a global view and some of those principles around data protection generally. We'll then talk specifically about the GDPR, its scope, what it means, who it impacts, etc. And then we will also touch on some of the response strategies or some of the things that organizations and enterprises are doing generally to respond to GDPR and what some of the most important elements of that are. So the USA has had numerous elements of data protection and privacy in place for several years, as with Europe. All of the privacy regimes, or at least the concept of personal or the right to personal privacy, dates back to 1974, where the OECD published a series of principles, data protection principles, that are really the basis of almost all data protection regulation that you see today. They may be defined in slightly different ways, but those original principles of the OECD continue to apply through the regulation. The USA is very much more of a sectoral application of data protection. So it is within healthcare and life sciences, within financial services, within consumer marketing, and the various different sectors of the economy have slightly different ways of being regulated and different regulators. Obviously, that just goes to that complexity of their economy and how the economy has grown and developed over the years. They also have they will already have had in the past a really good or robust program of breach notification or breach response to security and cybersecurity attacks, cybersecurity losses, technology attacks that have allowed them to develop a program or regime of almost a nationwide response to breaches of privacy. This will manifest itself in the new European regulation, and we'll talk a little bit about that in due course. And there's also then, and we'll talk a little bit about this as well, a state level and local level of application of these different data protection principles in the US. In Asia, you're also seeing that a majority of the Asian nations have got some sort of data protection regime in place. In particular, the larger economies, larger risk areas of India, Singapore, and Japan. Japan's approach was a very sector-based approach until 2016, 2015, where they began to deliberate on a new approach, a more national approach, a little bit.
Spearheading.
Yes.
Was there a question?
It's today and tomorrow.
Yes. I was contemplating swinging by.
Okay. Japan has in 2017 put in place their Act for the protection of personal information. In 2017, that became law. That is a national regulation, national law now that applies to all sectors, and is seen somewhat as an equivalent of the GDPR, or at least very much trying to align itself to that, with the expectation in due course that they might become adequate in the same way as several other non-European nations have adequate status to Europe in their regulation. So we will see how that works. The same goes for Singapore, where their full Personal Data Protection Act came into force recently, and now is going through the various steps of being deployed, in particular around ensuring that they have an appropriate enforcement and regulation regime there, which is where they're focused on. Australia, interestingly, is not adequate to the European Union regulations, but their regime is frankly very, very similar. Not much difference there. But we'll see how that progresses over the next few years. But certainly, the updated law is very, very relevant and quite a recent implementation. Africa has, I think, very different elements and different regimes in place. Some of them are very sophisticated, have been in place for a little while, and have the various enforcement practices in place that are quite consistent, whereas others have almost no privacy protection regimes as yet, and we'll see how that progresses over time. But certainly there is a very sort of differing implementation across Africa with those. Latin America, South America, again, differing elements of completeness in terms of their approach and their regulations. Uruguay and Argentina being deemed adequate by Europe, which of course, that improved access to data. Data can then flow because they are deemed as adequate from Europe to those jurisdictions and back, as if they were actually in Europe. And so it means they don't have to have in place those various safeguards that we'll talk about under GDPR for the transfer of data, because they are actually deemed to be adequate. Other jurisdictions within South America and Latin America are in various stages of completeness, with Mexico being very sophisticated and quite mature, but not actually adequate, although they probably will be and might look to do that soon. So that just gives a sense of sort of the global nature of these types of regulation and the thinking that regulators are that they're using to approach this. Very much aligned. There is a group, GPEN, which is an enforcement network of privacy regulators and enforcement bodies that are connected, beyond just this European adequacy status, and where there are a series of memorandums of understanding and other international agreements which allow the data protection regulators to collaborate and help each other in enforcement globally. So there is definitely a lot of tie-up and a lot of consistency continues to grow in enforcement. So it doesn't matter where you are, you're probably going to have some kind of responsibility for that. I would say the CTU certainly is accountable. It's important to have a robust compliance program in the various organizations. You're going to be accountable to members and to regulators in the various jurisdictions, and obviously internally, to colleagues, partners, and other stakeholders within the various organizations are placing trust in that compliance posture to ensure that their personal data is protected in an appropriate way. The business landscape in general, as we know, is evolving, and there's an ever-growing need and want to use personal information for various different procedures and practices. And so it's important to have some kind of consistent approach to how you do that. It's also important, that's important in the context of how you set up a compliance program within any enterprise, because whereas some might think that you can differentiate how you process certain information from others because they may be focused on or come from or be processed in different jurisdictions, you might apply a different approach to protecting the information. That becomes less and less practical when you think about this concept of the globalized use of personal information and how these procedures are becoming very consistent globally. Also, from an efficiency perspective, an organization would typically try to have the most consistent global approach to the way that they process information. They wouldn't want to try and differentiate by regulatory regime. So it becomes very complicated to do that. There are, as we said, globally, there are differing levels of regulation across various organizations, various jurisdictions. There can be local level or state level. For instance, if you would take the US example, where you have regulations that apply at a state level as well as at a local level. They will have slightly differing views on what is deemed to be personal information or personally identifiable information in the US vernacular. So they may be thinking, about just ID numbers or just financial bank account numbers or just health data, whereas, other jurisdictions may view it more broadly or more narrowly. And then there's federal level organizations and regulations as well that you need to take into account when you deal with these jurisdictions. And I'm sure that will be consistent within the Caribbean jurisdictions as well. Obviously, various EU and Canadian and other emerging market regulations that we talked about previously are coming into play and becoming more sophisticated and more effective as the enforcement bodies become more practiced at their art, and you'll have to be careful about how you operate in the various jurisdictions. So having considered that there are a number of different regimes, there is, as we say, a lot of consistency in how people and how the various regulatory requirements think about or articulate the different concepts. And so it might make sense just to go through a couple of the sort of key terms in the privacy landscape and within the regulations that will help us as we talk through both now and as we move into the GDPR as well. So personal information. Contact or locate an individual, either directly or combined with other
Hello, Greg.
pieces of information. Yes.
Greg,
Hello.
this is Nigel Casimir.
Hello.
Could you start over from this slide, this data privacy terms, because your audio dropped out for several seconds just now.
Okay, no problem. So we talked a little bit about the various jurisdictions and the various laws that govern across the globe. And while they are different, the terms that they use, because they come from this common origin of the OECD principles, they do tend to use the same terms, when they draft up the regulations and the legislation. And so it would make sense then to go through some of those common privacy terms just to level set our understanding of what those actually mean. So oftentimes you talk about personal data, or you hear talk about personal data, you talk about personal information, or you hear talk sometimes about personally identifiable information. All of those generally are talking about information that can be used to uniquely identify an individual, or contact them, or locate them. And it can be that information that directly is able to identify them, or it could be information that is used in combination with other information that could be used to identify a particular person. And I'll get onto some examples of that in due course. Personal data processing means any operation that is done with that personal data or that personal information. That means collecting it, that means looking at it, that means combining it with other information and manipulating it, it means deleting it, it means sharing it and disclosing it to somebody else. It's all of those operations are covered by a single term of data processing, and it's very much this data processing that is at the core of the GDPR and most regulations globally. Right of access is the term often used in the US, particularly in the health sector, and under GDPR and in the current European regulations, it is a subject access request, and that means that right of an individual to gain access or know about the processing of their personal information, and perhaps to get copies of that information in many cases, although there are some exceptions. There's a concept of a data controller, specifically in European regulation, and that means the entity that is responsible for determining or defining how information is going to be processed, and the nature and collection methods and storage methods of those of that data. It's very different from a data processor, which is generally a third-party service provider to a data controller. They operate on the instruction of that data controller, and they operate on the data and they collect information and use information only as it's necessary to respond to or provide the services that they have contracted to that controller. They shouldn't or mustn't use that information for any other proprietary purposes or any other purposes that are not consistent with providing that service to the controller. So that's how they interact with each other. There's a concept we talked about a little bit about a data breach or security breach, where there is unauthorized acquisition or use or disclosure or unintentional modification or disclosure of personal information or personal data. And in particular, we are talking about those data breaches that may reasonably compromise the security or privacy of the individual. While theoretically any loss or inappropriate use or disclosure of personal data will be a data breach, the regulators understand that some of these are quite innocuous, and it would be operationally inappropriate or unreasonable for organizations to have to respond to or report every time a small piece of information is used or disclosed, slightly beyond what it was intended, if it's not going to have any particularly great impact on the individual. So they try to impose some kind of reasonable balance to how you respond to these data breaches. A data subject is that individual to which that personal information pertains, and it could be anybody. It's not only going to be your customer, it's not only going to be a consumer, but it could be employees internally and your third-party suppliers of the organization as well. We talk about opt-ins and opt-outs for use of data. That is that concept of the data subject being able to determine or respond to the users, those data controllers or data processors, in terms of how they would like the information to be used or not in one case or another. The most common of these, obviously, is where you unsubscribe or object to processing your information for marketing purposes. That's typically the most common place that you see the concept of this opting in and opting out. Under GDPR, we'll talk a little bit about the fact that there is no longer, or there is not a concept of of opting out, but only of opting in. There must be an active action from the individual to say, yes, I want you to use my information for this purpose or in this way, not a concept of being deemed to have consented to that just because I didn't say something or I didn't uncheck a box that you pre-checked for me. I must actually be required to check that box or specifically say, yes, I agree for you to use this information. So there's no more silence taken as consent. Talking about that personal data, we talked a little bit about generally. This is personal information that's used to identify a natural person. Again, it's not a business entity. There were some jurisdictions that included some types of corporate data or about the nature of a corporation or an entity into personal data, like Switzerland. That's not the case anymore. The personal data is only about a living individual, especially in the European context. Data is a set of data that can be used in combination to identify somebody. It doesn't have to be a directly identifiable piece of information. It doesn't have to be a name of an individual or an email address directly linking to them. It could be a combination or a set of information. So, for instance, you may have a person's corporate title, such as Vice President of Marketing. You may have their postcode or zip code of where they live or where they work, and you may have that they graduated, their education history. They may have graduated from Harvard University in 1973. Now, if you combine those pieces of information, there may only be one or a handful of individuals that are the VP of marketing in Boise, Idaho in the US that graduated from the law class of Harvard in 1973. You could go with very easily accessible data such as LinkedIn, and you could identify that particular individual. So that's why it is not necessarily just that directly identifiable data that is covered now as personal information, but it's any data that could be used and combined with reasonably accessible other data to identify a particular individual. So keep that in mind as we think through the types of information. The types of information that you usually are going to be seen covered, especially under the European regulations, are those in the list here. And in addition to what you would call as just regular personal information, there is also a subset of information that we used to know as sensitive personal data. It's now referred to as special categories of personal information. What that is really just it describes a subset of data that historically may have been used to persecute people or to differentiate them. So it's physical and mental characteristics, racial or ethnic origin, your nationality, your family dynamic or orientation, political views, or religious views, etc. So those types of things that you usually connected with some kind of persecution are often included in these special categories. They've added under the GDPR biometric or genetic data. So of course those, as they map the genome, you're able to understand more about individuals and discriminate against individuals potentially because of a marker that you might find in their blood or their DNA that points to one or another, perhaps affliction or affiliation. So those are the key areas. Where do you find this information? It could be anywhere. Employee applications, onboarding, payroll, your HR data. Vendor contracts, and as you add those vendors to the accounts payable database, that information then becomes personal information in your finance and accounting departments as well. Of course, the obvious scenario of your customer relationship management databases and marketing databases, and then any of your consumer or customer account enrollment data as they enroll for accounts will become personal information. Thinking then just in terms of those principles that you want to think about and how you respond to those. The processing principles are going to be core to as you set up and create your data protection or privacy policies internally. You want to think about what are the principles that we're going to have and process on. Always ensure that you're notifying data subjects when there is mandatory data processing. So there's a lot of processing that is required. You need to report for regulatory purposes, or law requires that you collect certain pieces of information and retain it. You need to notify individuals that that's what you're doing and why you're doing it. You can't just do it and then not advise that individual, even though you're doing it because the law says you need to. You need to make sure that they understand that. In particular, the GDPR now has put a lot more emphasis on the legitimate interests of the organization, and we'll talk a little bit about that in a moment. But ensure that you still are required to advise the individual that you are processing their information and that it's for your legitimate interests as an organization, because you need to provide them an ability to exercise their rights to object or to understand or find more information about what you're doing and perhaps get copies of that. So making sure that you're doing that. Data limitation. So that is collecting only the minimum amount of information that you need for the purposes that you want to collect it for. You may be collecting information because you want to invite somebody to a particular conference or a gathering. Think about what you actually need to know about that person to invite them to this gathering. So you may need to know their name, you may need to know where they live, because you have to figure out what kind of travel arrangements you need to make. You may need to know about food allergies if you're going to be providing hospitality for them, etc. But you don't need to know everything that would be in a person's CV or resume. You do not need to know about their educational background. Potentially, you don't need to know about their job history. So you just need to think about, what are we actually trying to achieve, and what information do we minimally need to do that? That sort of also reduces the risk to the organization of collecting and having to house and secure a bunch of data that they don't actually need or don't require for the purposes. Data security. Think about the principles around allowing access to information, who can have access to it, minimizing that access to just those people that need access. Do not allow unfettered or global access across the organization to a database unless it's really necessary, and rather restrict that down to people that really need access to that information for the job that they do. Think about transparency and access, making sure that you are able to disclose to individuals who ask for it, what information is collected, why it's being used, who you might share it with, disclose it to for whatever purposes, and then how might that individual contact you to find out more about what you're doing with the information, or to ask you to use it or not use it in a certain way. Data transfer. Think about where and how you will transfer that, particularly under European law. You need to think about the safeguards you need to put in place over that information when you transfer it out of the EEA. If you are not transferring it to one of those jurisdictions that we talked about being adequate earlier. If it is not an adequate jurisdiction, then you need to have some sort of other safeguard. And we will talk about that in a little bit. I didn't know if it made sense now, Nigel, if there were any burning questions before we move on to talk about the GDPR specifically.
Just 1 second, Greg. Let me look at the room.
Okay.
Any specific question on No.
Okay,
No, you can go ahead to GDPR.
great, no problem. So yes, the EU General Data Protection Regulation, or GDPR. There are probably many in the room who never want to hear that phrase again, and possibly some that have never heard it before. So we'll have a look a little bit at what that means. GDPR covers the scope of the GDPR covers a number of different domains within the organization. The key areas, and we've touched on some of these. There are a number of different new concepts that have been brought in under the GDPR, such as the right to be forgotten, one of those subject access rights, or one of those rights of access that we talked about, where people are able to ask for you to purge your systems of all their data. The privacy by design, or privacy by default, where you build into a new process or new system implementation those procedures or practices that afford the individual or the personal data the highest protection that's possible, while still achieving your intentions with that new system or process. So those are there are a number of new concepts being added to under GDPR. Jurisdiction is one that often gets there's a little bit of confusion sometimes about the applicability in jurisdictions outside the EEA. GDPR has introduced extraterritoriality, which didn't exist under the old regime. That means that whereas current the EC 9546, which is the current directive that they operate under, the jurisdiction stopped at the borders of the European Economic Area, or EEA. GDPR says no. The coverage or the applicability of GDPR goes where the data goes. So if that information now is going across the Atlantic, the coverage of the GDPR goes with the data, and so that extraterritoriality kicks in. Now, one of the key things to keep in mind, it is not about citizenship. It's not about your residence status. It's not about your nationality. Oftentimes, when people talk about privacy, about GDPR, they talk about, this regulation applies to EU citizens, or they talk about if they are EU residents. That's, I think, used as that concept is used loosely, but it definitely creates a lot of confusion. And what I often like to say is the GDPR does not apply to EU citizens. And the reason why is that while the GDPR is talking about, or really sort of focused in on, the individual and their data, it actually doesn't apply to the individual. The GDPR applies to those entities that are using that individual's personal data, and it applies to the purposes that they use that individual's data for. So it almost doesn't apply to the individual at all. It applies to those entities that are using personal information. And then when you think about that, it focuses in on those entities that are established, that are based in Europe, or those entities that use personal information to provide a service or a product or complete a transaction within Europe. So it's entities that are based in or established in Europe, or it's entities that use personal information to provide a service or a product or a transaction in Europe. If your processing of personal information doesn't fit those two concepts, it's likely not covered by GDPR. But those two concepts do allow the GDPR to be applicable well beyond the borders of Europe. So an entity sitting in the Caribbean doing data processing or perhaps market analytics on behalf of an organization in Europe who sends them a bunch of personal information and says, give me analytical insights about these potential customers. And that entity, that organization within the Caribbean only uses that information within the Caribbean on systems based in the Caribbean.
Greg, I have a question.
An organization that is in the EU, or
Yes.
they're doing it on the basis of a.
Greg, can you hear me?
Yes, yes, I can. Sorry.
Okay. On this same jurisdiction issue, you talked about if in the Caribbean we are processing data on behalf of. Not exactly that, but related. We have, for example, British overseas territories here. We have French overseas and Dutch overseas territories here in the Caribbean.
Mm-hmm.
It would apply to persons doing business in and with those territories as well?
I was sure there weren't going to be any tricky questions I couldn't answer, but I'll have to, let me think on that just for a few minutes when we have the break.
Okay.
But it'll have to be, it'll probably be a nuance of the applicability of the European countries' regulations or laws within their affiliated countries in the Caribbean, those territories. I'm want to say yes, it would apply equally. They would be seen as being part of the Netherlands or being part of Britain for this context. But let me have a look. That's a great question. I'll have a look further.
Okay.
That makes sense. Okay, great. Personal and sensitive data, we talked about already, that those pieces of information that may have been used historically to persecute or differentiate against people. Importantly, thinking about the way that you can use certain kinds of information. The GDPR introduces the concept of pseudonymization. Again, there is sometimes some frequently asked questions around what's anonymization, what's pseudonymization, what's obfuscation of information, and how is that adequate? How does that, how do we apply that adequately for GDPR? So think about it in terms of anonymization being the most secret that the identity can be. And what that means is that you are able to remove enough of a record or information about an individual that it becomes impossible to identify that individual. So you might keep something like their postcode or the country that they live in, but you don't keep their street address, or you might keep the fact that their email address is on the Gmail domain, but you don't have the actual identifying aspects of their gmail.com email address. It's extracting enough of a record that makes the actual individual themselves unidentifiable, but might be able to retain other interesting information about them. The fact that you have 75 records that are all in the same postcode might still be very important to you or might be helpful to you. That's anonymization, and the GDPR has a very high bar, and it requires that in no way, using currently available technology or information, can you re-identify this record. And that includes that a decryption or re-identification key is destroyed and no longer available. So you may encrypt or hash or obfuscate or tokenize a piece of information like the street address. You may hash it, but then there may then exist a key to unhash that piece of information. For it to be anonymized, you would need to destroy that re-identification key, as an example. Pseudonymization is one level less secret. It means that you take out at least, and I'm just using a very broad example, at least the name and the email address and the street address and the phone number, etc. Those direct sort of things. You take out their organization, for instance, but you leave other things, like you may leave their town, you may leave their corporate ID, if that is common enough within that town. You may keep their zip code, etc. You may keep more pieces of information, but it makes it reasonably difficult for that individual to be re-identified, so that you are reducing the risk to that information or to that record sufficiently to be able to use it for the purposes that you want to, or be able to transfer it to another organization. They're all, similar to the previous example, you may hash some of that information or encrypt some of that information, but you keep the re-identification key available. So in some instances or examples of this are where an organization may have a list of customers in their customer database, but they want to understand perhaps or get information about what the buying patterns are of particular individuals, be they male or female, be they living in a certain part of the country or certain region of the country, so a combination of zip codes. And they may be, is in particular product sets they want to find out some information. Now, if you are able to, you don't need the person's actual identity or identifying information to be able to extract an analytical sort of insights from that data. So what you might do as the organization that has this list of customers is strip out the information, about their street address or who they are, et cetera, and then send over that pseudonymized information to your analytics provider, who's going to be doing the analytical, has the analytical tools to look at that information. They then, on that pseudonymized list, data set, do their insights, and then send you back something like, well, if they are in the northeast of the US and they buy the following combination of products, they are more likely to be interested in the following other combination of products. So you're not actually able to identify any of those individuals from that data, but you can now take those insights and then re-identify your database and say, yes, it is these 20 people who live in the Northeast and have this buying profile who might be interested in this other buying profile. And now you're able to re-identify those and then make those suggestions to those identifiable individuals. So you have pseudonymized that data in order to be able to transfer it over to others, and you've made it reasonably difficult for them to re-identify those individuals from that data while still being able to use that information. Those are types of strategies, things that you can use, that you can do with that data to make it more usable. And it is something that is going to become quite interesting in the future in terms of how people actually apply those different kinds of strategies. We talk also under the GDPR about governance and accountability. That is really just saying, make sure that you have a well-documented approach, program that shows that you are keeping the organization as a whole, all the stakeholders within your organization, so HR, finance, marketing, sales, IT, all of them are being appropriately kept up to date with what they need to or should be doing, that you are able to work with them to quickly introduce new practices and procedures if you need to, and you have them in a lot of organizations create a data governance council, which has representatives, for instance, of those various stakeholder groups, and they can be contacted from time to time, depending on the need, and told what they need to do or change. And you sort of have those meetings, perhaps on a regular basis. That's one way of showing that. Another element of accountability is making sure that you have a leadership structure within the organization to govern your privacy compliance. That would include, in some cases, it's not in all cases, and it's not necessary in every case, to have an actual statutory data protection officer, which is defined within the GDPR. Some organizations do, depending on what kind of information that they process, how often or how much of that information they process, how large or complex their organization is. You may be required to have a data protection officer, but you don't always. There's only certain organizations that need to have that. But you do, in order to be able to respond to or make comfortable a regulator that you have a good program in place, you do need some kind of governance structure with some kind of individual that has some accountability for it at a reasonable level of seniority within the organization. So that's different from, so a lot of people will say, oh, we don't need a data protection officer. That's not the same as saying we don't need a governance and accountability structure within the organization. You always need that. And depending on how large or complex your organization, it may be a large or complex governance structure. But separate to that, some may or may not need that data protection officer. They are definitely two very different things. It also includes things like making sure that you have good policies and procedures in place that are well understood and well socialized within the organization, that people are able to understand what the policies of the organization are, what is required of them individually, that there is good training to give them that awareness and keep them up to date with how things should be done, and making sure that you have an approach to putting in place that privacy by design. Privacy by design is another important element of that accountability principle, whereby you're making sure that you're thinking about privacy each time you do something new with information. Also, keep in mind, it doesn't necessarily mean that it's an IT or technical change that you're introducing. Sometimes there are a number of instances where you would still have to do or should do a privacy impact assessment, even though there may not be any change to the technology. It could be that your marketing organization begins to ask for a new kind of data from their customers that they didn't before. But the technology, the database, the CRM database they have, has already got the functionality to receive and process that new piece of information, like their prescriber identification number if they're a doctor, or where they went to school, which you didn't have before, but the database may still have those fields available. So you can see that there may not be any technological change, but you still now need to think about, well, now that I'm collecting this information, does it impact the risk to to that database, to that CRM system? Am I collecting more information now that makes the entirety of that database more risky or more sensitive for processing? So there may not be any technical change required. So consider that when you think about that privacy by design approach. It doesn't necessarily need to be an IT change. Although I will say that in the vast majority of instances, organizations will start from the IT realm, because obviously there's a lot of experience and sophistication in the technology the department in terms of how they manage new implementations, manage new projects. They have a lot of skill in that, so you would probably base your initial procedures off of what they do and how they do it as a starting point. Consent. That is one of the laws lawful bases or legal bases that you might use to process or collect or use personal information if the individual has given you their consent to do so. Under the current EU regulations, consent is the most prominent way to use somebody's information or make that lawful. But the GDPR makes consent, makes a lawful consent or an adequate consent much narrower. You have to be much more granular in the information that you give to the individual before they consent, or in order to ask for their consent, it needs to be much more granular, much more focused, and much simpler. You can't bury the consent in your standard corporate privacy policy page that nobody ever reads because it's nine font size text that goes on for pages and pages and nobody ever reads it. And so you sort of bury that consent by, if you continue to use our product, then you have been deemed to have consented to what we do with your data. That's no longer possible. Now it needs to be separate. It needs to be very specific and very clear what you're trying to do to be able to get that consent. But to balance that, the GDPR has also said there is much broader applicability of the organization's legitimate interest. And so a lot of organizations are now pivoting from using consent, which was used much more broadly than it should have been, to legitimate interest. When you use legitimate interest, you need to be thinking about what you need to disclose to the individual in order to do that. So you still need to give them information about what you're doing and why you need to use that information and for what purposes, who you will be sharing it with, how long you will process the information for, and how they can contact you if they want to voice their objection or get more information. So you still need to disclose that information, but you are not asking for the consent. You are saying, I am going to process your information for the following purposes. Here's how you can contact me if you don't want me to do it. But it's not the same as consent, and that is very helpful for many organizations, as I imagine you can appreciate. One of the sort of frequently asked questions around this is, I've been told that I need consent to market directly to individuals. So does that mean that all the information and all the records that I have in my customer relationship database now are no longer lawful under GDPR because I don't have this sort of GDPR consent? No. In the first instance, GDPR, recital 47, specifically says that direct marketing is part of an organization's legitimate interest. It's in your legitimate interest to market directly to individuals. So you can do that. You do not need consent under GDPR to market to individuals. But one of the nuance there, where this sort of sometimes sort of misunderstanding comes from, is that under some of the electronic privacy and cookie directive regulations, which govern how you are able to use people's electronic information and how you're able to send them emails, that does require consent. But the important thing to note is that the consent that you require under those cookie directives, that electronic marketing regulation, is not the same as the consent you require under GDPR. So you can have deemed consent. You can have non-explicit consent for each and every operation that you do. You can get a blanket consent. For instance, they are, and this is still to be confirmed and defined specifically within the new regulation for the new cookie directive. But for instance, they are looking at ways that you can leverage your browser selections and the indications that you make in the browser that you use to browse that organization's website may have indications in there built in. And so you set those limitations, or you set those requirements once in your browser, and that information gets given to the organization in any organization that you then go and browse using that browser. So that browser might say, no, don't market to me for whatever case in whatever instances, or it says do, or I'm okay with you to do so. That is a different level of consent than the GDPR consent. And so that's where there's sometimes this misunderstanding. You do not need consent to market under GDPR. It is in your legitimate interest to do that. You just need to make sure that you give an opportunity for the individual to opt out or exercise their rights to understand what information you have and how you use it and who you share it with. So you need to give them that availability, but you do not need their consent. You do need their consent under different regulations, but though that consent is not of the same level as GDPR. So hopefully that is clear to everybody.
Keep individual an eye on the time.
Yes. The individual rights. How are we doing for time?
I was just saying, keep an eye on the time.
Yes. How are we doing for time?
We are 2/3 of the way through. 30 minutes more.
Okay, great. So yeah, we talk a little bit about those individual rights. There are 7 of them, including that they call these data access rights. That allows you to have access to your information. That means potentially get copies. You must know what organizations, what data they have about you and what they're doing with it, who they're sharing it with, how long they're keeping it for. All of these rights, some of these rights include the right to access, the right to object, that means opt out or unsubscribe, for instance, and there is a right to erasure. There has always been a right to erasure. There has now been a little bit more gravity given to that. There is also part of right of erasure is what they call the right to be forgotten. Now, it's important. All of these rights are not equal, and they are not all absolute. An individual has an absolute right to request a copy of the data that you have about them and to know what you're doing and why you are using that information. They do not have an absolute right of erasure or the right to be forgotten, or the right to portability. Right to portability means taking information in a machine-readable format and transferring it from one service provider to another or one institution to another. Those rights are not complete. You will look at the reasonableness of them. Are you able to give them that right? Are you required, for instance, to retain data for regulatory or legal purposes so that you can't give them that right to be forgotten? You cannot erase all of their information. An employee may say, I have now left your organization and I want you to erase all data about me that you have. You would respond that in some instances you can, but in many instances you can't, because there are regulatory requirements that you maintain the data for several years after their termination. So they are not all absolute rights. There is some difference in that. Transparency and integrity. Again, we talked about making sure that you are able to disclose to individuals quite easily where you got the information, what you're doing with it, and who you're sharing it with. Security breach and notifications. Couple of key elements here. If you have been dealing with US organizations historically, then you will understand this is a relatively well-known concept. Under GDPR, it is new. Under GDPR, it's required that in the event of a data breach, the data controller, and this is important, not the data processor, the data controller is obligated to report to the regulator, their local regulator or the applicable regulator of the member country that they're operating in, or multiple if they operate in multiple. The data controller must report that data breach to those regulators as soon as possible, but in any event, no later than 72 hours after they become aware. Now, important thing here. Number one, the data processor must be bound or must commit to similarly report a data breach to their customer, to the controller, as quickly as possible, so that customer can make their reports to the regulator. But they are not required to report within 72 hours, and the 72 hours that the data controller, that the customer has to report to the regulator, doesn't start until they are notified, or until they individually understand there's been a breach. So if the processor has a breach, the service provider has a breach, but it takes 2 or 3 days to tell their customer that there was a breach, and the customer didn't know there was a breach, their 72-hour window only starts once their provider, the service provider, has told them about the breach. Then they can do whatever necessary investigation and notify the regulator. Now, of course, the controller should then notify as soon as possible and not take 72 hours if they can help it, but they do have then those 72 hours. So it is quite an onerous thing, because there is a lot to be understood, or to find out about a particular breach before you can notify in a reasonable way. But that is the requirement. International transfers from Europe, they are saying that if you are transferring information away from the European EEA regime, it can go to another country that has adequate lawful protections, or it must be covered by or bound by some other kind of safeguard. And those safeguards are enumerated in Article 46, and they include those things that we know about. So it is the model contractual clauses between the entities that are sharing the information. It could be Privacy Shield, which is an inter-institution agreement between Europe and the United States, or it could be binding corporate rules, which is a program, a compliance program in a particular organization that has been reviewed and authorized by the necessary data protection regulators within Europe. Binding corporate rules has become a lot easier, but it is time consuming and it can be expensive depending on how complex your organization is. But it does give you very extensive positive results, because you're able to then transfer information within your organization wherever you want, whenever you want to. You don't have to worry about those safeguards. Data processors, we talked about what they are and who they are, and we talked about the remedies. We'll talk a little bit about remedies in the next slide here, where we talk about the risks to organizations of GDPR. There is litigation risk, so that is that the data protection authorities now can bring suit against organizations, but unlike the old regime, there is also a right to class action style lawsuits, where a number of different individual data subjects can band together and pool the costs of bringing a suit against an organization, which wasn't available under the old regulations. And of course, that makes it much greater risk to organizations, because they'll be responding to a much better funded lawsuit. There is a financial risk. We hear a lot about the 4% of global revenue or 2% of global revenue, depending on the kind of violation. 4% is in the cases of an egregious violation. There's not going to be, hopefully, many that are going to fall into that trap. Someone will have done something and will be trying to do the right thing, and you will then get, obviously, proportional amounts of that type of sanction or fine. So, it depends on whether you've been completely comatose for the last 2 years and haven't heard of GDPR, and then have been egregiously not doing anything about it. But usually, those fines can be extensive, and there is particular, scope for that for DPAs. I think the most important one to think about for a lot of organizations is the operational impact or risk of GDPR. There is an expanded scope for the data protection authorities to come and do inspections and to follow up on complaints. They have to follow up on all reasonable complaints, which means that they can come in and they have the ability to come into an organization They might tell you about it in advance, or they might come in a dawn raid. And they may say to you, cease and desist all data processing of personal data. Now, for many organizations, that's all they do all day is process personal data. So you've effectively shut that organization down. Now, whereas in litigation, where they come and they try and fine you for 4% of your global revenue, you can litigate against that and you can get all kinds of appeals. You can't appeal against a cease and desist order for the inspection, or by the time that you've actually gone to court and appealed against it, the damage is already done. So, that is the operational risk, being ready for that happening and making sure that you're doing all the right things to try and ward off or avoid any of those complaints is very important as you move forward. So those are some of the sort of key risks. How does this impact organizations? We've talked a little bit about this already. The scope, many more entities are covered by the GDPR. It covers organizations outside the EU, not just inside. We talked about those subject access rights, what they're able to do and what information we should have available to give to individuals. We've talked about the legal risks of those class actions and inspections. And we've talked a little bit about those requirements to have a good, secure posture, secure the information that you have about individuals, particularly where you are processing the information for your own legitimate interests. Make sure that it is well secured, because it would be the worst thing in the world for you to be using these under your legitimate interest and then go and have that data impacted by sort of a nefarious act. Make sure that you are thinking and collecting these lawfully under that correct lawful basis, be it consent, legitimate interest, the individual's rights, or any other. Making sure that you have those cross-border transfers thought about as well. And then, in terms of the GDPR, a couple of sort of key topics just to bring your attention to. One of them, can everybody hear? Yeah. One of them is that security in the data breach, making sure that those Article 32 of the GDPR that require that you put in place those appropriate organizational or security measures are put in place. All those organizations that have a general, well thought out and robust information security program will likely be completely compliant with Article 32. It is not asking for anything significantly more than you're doing to secure your data today, but it's just making sure that you are keeping abreast of those and making sure that those are well placed in your organization. We'll talk a little bit about the state of the art in 1 second, but just thinking about those, the reasons and when you should report to the data protection authorities. It is quite a short window of time. It's not 30 days or 60 days as those breach notifications are in the US. It's a significantly shorter period of time, so you do have to act quickly. Another key topic that often isn't talked about but will be talked about quite soon is the state of the art. In the US, particularly, state of the art often means the most glorious bells and whistles, the best and most bleeding edge technology. That's not what the GDPR requires. The GDPR just means take account of what the general market approach and the market practices are today. So, for instance, if you were historically monitoring things on a manual basis, you were looking at log reports that you get out of the log files of systems. You were doing that on a monthly or quarterly basis, and an individual was having to look through those and figure out if there were any anomalies. Because there wasn't a solution, an automated solution to do that, to flag those up, then that was what you had to do several years ago. Today, there are many solutions that are able to automate that response and to review those logs on a minute-by-minute real-time basis for any kinds of trending anomalies. So if you come along and a regulator were to come in and say, how are you monitoring the security of the data, and you show them this manual approach, they will say, you are not keeping up with the state of the art, you are in violation of that principle, because there are endless opportunities that you could have done this in a more automated and much more secure fashion. So just thinking about making sure that any controls that you put in place and the way that you operate you are reviewing it and ensuring that it's up to date in a reasonable period. So every year, every couple of years, however that might work for you. And then in the last few minutes, I think we have just wanted to talk a little bit about how organizations are responding and some of the key things you want to, kind of key concepts you probably want to think about as you respond to GDPR in particular. So it's going to be a lot of collaboration and synergy is going to be created or has been created between parts of the organization that didn't really talk to each other before. So for instance, marketing and information security, or the CISO suite, probably never used to talk to each other. Now there is probably a lot more collaboration because in order to be able to respond effectively and in a way that's sustainable, these organizations need to talk to each other. So think about putting to place or collecting together those individuals that are representative of all the different facets or stakeholders in the organization, and creating those committees that are able to think about your approach in a holistic way. Making sure your communications across the organization, especially and including training, are well thought out. Think about the policies and procedures that you need, and by that I also mean that you really do need, as opposed to in a lot of organizations I find they have a lot of policies that 90% of them say the same thing. So they might have 5 different information security policies that could easily be converted into one that says the same thing in a clear way. Think about those incident responses and whether you're able to apply the same responsiveness wherever your information is used. A lot of organizations do a really good job having a very responsive regime in the United States or in your home territories, perhaps in the Caribbean. But if you were to have offices operating in Europe, you may not be able to apply the same responsiveness. So, you may have your external legal counsel can respond to you, within 4 hours in Barbados, but they can't give you a 4-hour SLA in Paris. It might be several days because they have to call a bunch of people. So, think about that and make sure that you have an appropriate policy and approach across the board. This is a implementation framework. It's just really thinking about the key areas that you need to respond to or need to think about putting in place procedures for. Most of these, I think all of them, we have talked about. It's making sure that governance and accountability framework is in place, that all the members and stakeholders in the organization are aware of what they're supposed to do. Think about that privacy impact assessment and privacy by design. How do you do that? How do you leverage perhaps your software development lifecycle, the SDLC process, and perhaps just make that broader and more applicable across the organization, for instance? Think about your breach response and being able to do that in the time that you need to do it. Data processors, those third parties, how are you making sure that they can support your compliance? It is relatively simple to do that, you would imagine. Go and find their contract, find out what rights and obligations we have from them, and then update those as necessary according to what GDPR requires. In practice, it isn't particularly more complicated than that, but it does become complicated in the actual application because, for instance, where are all the contracts? Do we have copies of those? They're usually kept by or distributed to everywhere within the organization. Sometimes marketing has their own contract, sometimes legal team keeps most of the contracts, or some of them, or all of them. Sometimes you have a procurement department that perhaps has a full set of those agreements. But in many cases, you don't. They're anywhere in the organization, and it's collecting them all together and figuring out what you have and what you don't have. That becomes very, very time consuming, and it's important to have some good, efficient ways of doing that. There's been a lot of lessons learned by a lot of organizations in how to do that. Make sure that inventory of the procedures and the processes and the kind of information that you process is put in place. It's a fundamental requirement under GDPR. Under Article 30, that you have a record of processing activities. Again, not particularly complicated. You have to understand what the pieces of information are, where they're held, whether you share them with a third party, how long will you keep them, and how are you securing them, and is there appropriate security around them. That's really all that you required in that inventory. But then going to each organization, understanding what systems they use, what kind of data they actually use within their processes, is that time-consuming piece. And there are a number of ways that you can do that quite efficiently, but it is something that needs to get done and can be time-consuming when you get until you have it in place. Data subject access rights, making sure that you have across the organization, your customer service people understand when they receive one of these, that they recognize it for what it is, and they're able to escalate the requirement very quickly, because you only have 30 days to respond to those subject access requests. And sometimes that can be quite an onerous task to find out all the places that a person's individual information is captured. And so you do need to have thought about it, even though you don't have a perhaps automated response. Some organizations make the mistake of trying to put in place a one-button solution to delete an individual's data across the organization. That's not necessarily where you want to apply your energies. For one thing, it's probably going to be very rare that you get an actual right of erasure or right to be forgotten request. And in those cases, you will then have the right, and you should take some time to understand what it is this individual actually wants, so that you can apply the response appropriately for their good and your own. And so, you have time, but you do need to understand this right of erasure request has come in as quickly as possible, so that you can put in place the necessary steps to do it, even if they are manual steps. A couple of additional thoughts as we go through the considerations here. We talked about those privacy policies, the policy and procedure hygiene. Make sure that you have the minimal number of policies for the individual employees within your organization or your service providers to respond to, because you can imagine how difficult it is for an employee to have 5 different policies that say slightly different things that they're supposed to comply with. So what they will usually do is then ignore all the policies, because there's just no way that an individual can respond to all those different things. So it's really important to have that good policy hygiene, that everyone's aware and straight with what they're supposed to do when they're supposed to do it. It gives you that comfort that things will get done the way that you need them to be done, in a consistent way, and that's very, very important for compliance. Realign the processes that are going to be practical and implementable and sustainable. It's the most important element, is that it's sustainable across the piece in the organization. And then think about, as a maturity step, not necessarily that first step, but think about tools and automation. How might you be more responsive to that state of the art? If tools and automation are now available for a control that you put in place perhaps 3 years ago, is it important that you need to then look at that and say, yes, almost it's easy to do, it's not very costly, we should do it, because the regulator will come along and say, well, it was not costly, it wasn't onerous, you should have done it, and you would have been much more secure than you are, and now we've had a data breach, and a lot of information was lost because you were doing this in a manual fashion, where you actually could have had this in an automated fashion quite a long time ago. So, think about that as a maturity step for you to do. And then finally, make sure that training is, digestible for the organization, it's timely, and it is in a manner that is, they can respond to and work with easily, as opposed to 3 hours of very dry policy regurgitation. So those are sort of very rough canter, very brief canter through everything that is GDPR, and hopefully we will have some enlightening questions to come.
Okay, thank you very much, Greg. Was that the last one?
That was the last one. I think we were thinking then to just
yes,
move on to
okay.
some other topics.
All right, thank you very much.